word law means, and that's your contract. And the bench, the magistrates, okay, they turned around and said, the bench is telling you it's not a policeman's job to know the difference. This is the ignorance that, sorry, nations is the right word. Ignorance means you're ignoring the knowledge. And again, this is a new word I was introduced to, okay? So this highlights the problem, okay? So basically, he who creates can uncreate. So, who created the Bill of Rights? We the people. They've claimed that we the people gave them authority to do it. Therefore, we the people are the principle. Who can uncreate it? Only we the people, nobody else. Parliament can't change it. They have no authority, because that's the authority which creates them. So by impossibility, they cannot change the Bill of Rights. Okay? And so, with this here, hopefully you can have this idea or the understanding. Everything is principal agent. Okay? It's delegating authority. That's called the chain of authority. So when anybody pulls any, regulation da-de-da, in its introductory text, it will tell you what's the source of the authority. So let's look at the council tax. The council tax admin and enforcement regulations is their claim against you. Here's a bill and this is what allows me and authorizes me. Yeah, okay, that gives you legal authority, but does it prove my obligations? The question. So, okay, where does your claim arise its authority? And it says in the introductory text, Local Government Finance Act 1992. So we go to that document. Where does the Local Government Finance Act 1992 gain its authority? In its title page, it tells you, be it enacted by the most gracious monarch, by and with the advice and consent of the Lords Spiritual, Lords Temporal and Commons, in this Parliament, assembled by authority of the same. Well, you guys created it. You guys advised and consented on it. Therefore, guess what? You guys had a meeting of the minds. Therefore, it's only binding on you guys. It's got nothing to do with me. Unless you can prove joinder. They can't. Okay? So, that is called the chain of authority. Always, you need to look for the chain of authority and the relationship. Okay? So you need to understand the relationship. So that's legislative authority. None of us can evidence we were around at the time. Therefore, what makes them, where do they get their authority from? The living people. Okay? My word is my bond. That creates duties, rights, and obligations. Therefore, the Coronation Oath Act says, when the last person's died, the next monarch will make a promise. That is the contract with the people. The oaths, affirmations, and attestations are the contract. So, the first promise is to govern the people of, it lists all of the places that they have got control of, according to their respective laws and customs. In the Coronation Oath Act, it actually says, using statutes in Parliament agreed upon, and the law and customs. What is that telling us? What does the word "and" mean? One thing, and another thing, and another thing. Three constraints admitted there. So, what constrains Parliament? Statutes in Parliament agreed upon is one. The law is something different which controls them. And customs. Okay? So, statutes in Parliament agreed upon is the written constitution, the Bill of Rights. The law is the unwritten constitution, because we create the law in the courts, and we'll go through how. Okay? And the customs. So there's three self-admitted constraints. And the law is the unwritten constitution. Okay? So, that's the first promise, to govern, and they govern as a principal agent, where the people are the principal. The Parliament assembled is the agent of the people, and Parliament assembled is the principal of the government. The government is the agent of Parliament assembled. The second promise then creates the independent judiciary. How do we know this? Well, here's promise 1, and here's promise 2. Okay? And so the second promise creates the independent judiciary. So this is in not necessarily our lifetime. However, this is much more current than 1688. Okay? And it's expressed that when there's a problem in there, like we saw earlier, I can take any existing common law precedents, argue the rules of equity to improve that and make it more fair and just for me. All right? So when Michael and I brought the claim against Matt Hancock, okay, I actually signed the arrest warrant for Matt Hancock. Gee, wow, I can go and get Matt Hancock arrested. Guess what happened with the Boris Johnson judgment? So what we did was a criminal case, but you, every one of you, can do this. That's how powerful we are. And they will do it. In the civil side, you had Gina Miller, and who was the girl from Scotland? Can't remember her name. Individually took the Prime Minister to court and won. That's the power we hold. That there is how we get the unwritten constitution, the law. Okay? The law starts to fill in the details that aren't expressed here. Okay? So, the prejudice of the people, Parliament itself admitted, is your birthright. That's how we define it. Okay? Beyond that, we looked at what makes something have the force of law. It must have a legitimate aim. How was that created? Somebody went to court and argued this. And the judges agreed and wrote the law. All reasonable options must be considered. It must be rational. There's now another constraint of Parliament. So if you go on the Parliament website, if we've got time tomorrow, we'll do that, just so that I can show you how to go through legislation of it. It needs an impact assessment. And what's an impact assessment? Show me the legitimate aim, show me all reasonable options have been considered, and show me the proportion. Go through all primary legislation. None of it has an impact assessment. Therefore, by admission, it's got no force of law. Okay? So this is how we create the details as to what they can do.
So where's the requirement for an impact assessment come from?
If you look under any piece of legislation, you look under the tab called More Resources, and in there one of the options is impact assessment, and most of them will say no impact assessment.
But where's the requirement for the impact assessment come from?
Through what I showed you earlier in the law, you need to show legitimate aim, you need to show all reasonable options are considered. Where does that come from? Let's go back to absolute basics. Nobody's above the law, all are equal under the law, and we all have an obligation to keep the peace. Therefore, I must apply the best available knowledge, due diligence, before I impose my will on you. What's health and safety regulations all about? Due diligence.
Risk assessment.
Risk assessment. Why? Because I must apply the best available knowledge so that I don't knowingly cause you harm. It all comes from the same simple stuff. So what I'm trying to do is just show people the simple stuff. Don't worry about the detail and instructions. Understand the foundations, because the foundations are really simple. So the second promise, so this is the first promise, to govern. I promise to govern according to statutes in Parliament agreed upon, and the law and customs. So where does the law come from? The second promise creates the independent judiciary, and we're going to look now at the independent judiciary. So from what I've said, by their own admission, it says in their own acts of Parliament, legislation, law, customs, and means by their own admission, legislation is different from law, and law is different from customs again. So how the hell can anybody think legislation is law? I just don't get it. Okay? But this is the problem we face, the belief system. So the second promise creates the independent judiciary. And what we're going to look at now this afternoon is basically what is the independent judiciary and what it is all about and how does it actually fit in. The separation of powers is you've got the legislative body, you've got the executive body, and you've got the judiciary. That's how they sell you the separation of powers. Okay?
Can you say
We-
it again, Mark, please?
Yeah. You're familiar with the concept of the separation of powers? Okay, this comes back from, I don't know, 1700s French philosopher. But basically, you have an independent body that creates legislation. You have an independent body that governs, or the executive body executes. Okay? And you have an independent body that's the judiciary. Okay? So the way they're selling it to you is the balance of power. Hang on. Okay? What you've got is the judiciary is independent from the independent legislature and independent executive. So, if there's an issue between the two of them, it goes to the independent judiciary. Okay? But what we've seen from the Bill of Rights, the Bill of Rights says this is bullshit. Okay? The legislature is the principle of the executive. So the concept that they're trying to sell you is not borne up by admission of themselves. So why have we got this stupid idea in our head? So the second promise is all about the independent judiciary, and it has one simple purpose. Because all are equal under the law and nobody's above the law, it needs to settle dispute. If you cannot sort out your kiddie stuff in private. Why? Because you guys need to sort out your nonsense, otherwise you're breaching the peace. And if you guys can't sort it out in private, then one of you brings it in because they believe they have a right for public dispute resolution. Now this is extremely important to understand this, okay? It comes back to default judgments. How do I respond to a claim against me? All right? And we'll be looking at that. So the judiciary, okay, is independent. Allegedly. Okay. So basically, the first issue people have with the judiciary is when you go into the courts, all rise. Do you know what that means? Okay, you've got this coat of arms above the judge's head. That there is the monarch in the judiciary, just like we have the monarch in Parliament. Okay? The monarch enacts, or grants the authority to enact the will of Parliament, and to enact the order of the judiciary. Okay? That's how we, the people, are represented on the specifics, not the generalities of voting, to stand on our rights. Okay? So basically, when you're standing, you're not standing for the judge. Okay? You're standing out of respect that that little coat of arms is my power. And all of us better uphold it. So we need to know what's going on. Whether you stand or don't, what difference does it make? No. Honestly, it makes no difference. It's not saying I'm submitting to you because you said everybody stand.
Mark, what if you were joined into a court where there's no country?
Then it's not a court of law. Okay. So basically, it's not really, it's very much misrepresented. Okay, what's the second promise? Will you to your power cause law and justice in mercy to be executed in all your judgments? That's it. There's the contract. Guess what? Who offers this contract?
The people.
The Archbishop. Okay, the Archbishop of Canterbury offers these contracts, the promises. Okay, the first promise, will you govern the people? Second promise, will you to your power? Okay, so what's going on here? Remember we said authority, chain of authority, relationships. The Archbishop claims to be God's representative on earth that can offer these contracts to the monarch to govern, to set up the judiciary, to uphold the independence of the church. Nobody's challenged these claims.
Firstly, who gave him the authority to be God's authority on earth?
He who stands on their rights harms no one. Nobody's challenged it.
And secondly, what happens to the new coronation if the next coronation doesn't list these responsibilities to the monarch?
Then we bitch and moan. Ultimately, what's going on is a trust relationship, okay? And so long as they act lawfully, it makes no difference to me. So, what's the true relationship? The true relationship is expressed in Genesis 1:26 to 1:28. It's a trust relationship. So what happens is, the Creator God, they call him here, created everything, okay, and has granted us the two things. Granted us the beneficial right to the seasonal fruits and seeds, and the dominion. And what does the word dominion mean? I have a fiduciary obligation to look after this grant for future generations, i.e., whilst I'm living, I have two obligations. One, I have the right to the seasonal fruits equally, because he didn't say unless you're from this family or this is your name or that's your name. Okay? So I'm entitled to equal benefit from all of the global resources, so long as I don't knowingly cause harm and deny future generations their beneficial rights. So it's a trustee relationship, where all of us are equally entitled. However, under trust law, what's happened is, through governance, they have trespassed on our equal share. Okay? And in common law, when you trespass on a trust, and you don't need to know you're part of a trust, and you don't need to know that you've trespassed on a trust, you become accountable and liable. So that's what's happened in fact. And in the Bill of Rights, it actually accepts that responsibility by saying, yeah, we'll govern according to your laws and your customs. We'll do whatever you ask us to do, okay? And we won't do anything to your prejudice, right? So the trust is actually expressed in the Bible because the oaths are made to that higher authority. That's the accepted higher law. So the highest written law is the Bible, the King James, whatever version, is the highest written law. However, equity prevails, because who's to know whether this version of the written law is right, or the Islamic version, or this or that, or anybody else's. Therefore, equity is accepted as the universal connector. So, yeah?
So when you walk into a court, and
Yeah.
that coat of arms is there, which is the monarch in the court,
Yeah.
the monarch said they will rule by God's law and the customs.
No, they said they'll govern,
Govern.
okay, not rule.
Yeah, sorry.
They'll govern you according to your law, and your law, and your law, your birthright, your birthright, your birthright, all of our birthright. Why? Because we're all equal under the law, nobody's above the law. So it's perfectly equitable.
So where does the statutes come into?
So the statutes, okay, are no different from McDonald's company policy. How will I govern you? How will I fill in the detail to fulfill the mission to govern you according to your law? Okay, so it's the policy to uphold the obligations that are created to govern you according to your law. How will we do that and fulfill our promise we've made to you? So Acts of Parliament are the policy they use to fulfill their obligation to each and every one of us. It's got nothing to do with us. It's their policy, how they will deliver their promise. Okay? So legislation's got nothing to do with us. But
Unless we consent.
unless we consent.
Yeah.
Yeah. Okay, so that there's the first admission that the judiciary is independent. Whoops. Sorry, I'm not really familiar with this version of Windows. Okay, so now what happens is we have a principal-agency relationship. The monarch is just making this as head, and therefore the monarch is the head trustee. What the monarch then does is it delegates all of this authority to everybody else. Okay? So if you've got a problem, you can't complain to the monarch. Because I'm offering you the Lord Chancellor's position, and your promise is, I, Hugh, do swear that in the office of, Lord High Chancellor of Great Britain, I will respect the rule of law, defend the independence of the judiciary, and discharge my duty to ensure the provisions and of resources for the efficient and effective support of the courts for which I am responsible, so help me God. So if you've got a problem in the courts, it's no point going to the Queen, because she's delegated the authority. So the Lord Chancellor is the guy that we've got to go after for that, if there's a question of independence of the court. And simply, independence of the court is, if the court shows anything, and we'll look at this, which raises a suspicion that they're not independent. Therefore, whenever in the court they say legislation, blah, 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 there's your admission the court is not independent. Therefore, whatever judgment comes out of there is void, because it's showing a prejudice and that it's an unlawful administrative court implementing the will of Parliament.
Sorry, could you repeat that?
No.
Right. So, as soon as in a court they accept a piece of legislation, they are admitting that they're there to implement the will of Parliament, okay? i.e. they are not independent, they are biased, and by definition that's an administrative court where they tick box for anybody else to implement another's will. Okay? So by them saying, in accordance with this piece of legislation, they are already saying they're biased.
Is it on any charge?
On any charge.
Any
Any charge.
legislation?
Any charge. Any piece of legislation, they should be coming in accordance with the common law precedents, R versus Howe. You've breached the peace, here.
Is that why Howesbury wrote what he did, or did Howesbury write what he wrote?
Oh, I don't know. I don't really go into Blackstone, Halsbury, and you'll see I do talk a bit about them. But basically, why? It's so long as it's saying the same thing, it stood the test of time as truth, and therefore